Well, what was the matter of public policy that you think was stifled in the Andrew Bolt case?
Well, in the Bolt case, and you've already referred to this, Mr Bolt called into question whether or not a particular payment, government payment, should be available to a group of people because he challenged whether or not they were eligible for that payment. Effectively, that's what it amounted to. Now, interestingly, Emma, those people didn't sue for defamation. They could have said that Mr Bolt, by making the allegations he did, had defamed them because he had asserted or implied that they were, in effect, ripping off the system. But they chose not to sue for defamation. They chose to sue under the Racial Discrimination Act, and their argument was not that they'd been reputationally damaged, but that that what Mr Bolt said should be prohibited as political comment, and that is the vice we see in the Act as revealed by Justice Bromberg's decision in that case.
The central issue in the Bolt judgment was not whether Mr Bolt's articles were an expression of opinion, but whether the factual allegations on which that opinion were based were accurate. The judge concluded that the case was not about freedom of opinion, it was about freedom to spread untruths. Are you saying that freedom should exist?
Yes, I am. I mean, not in all circumstances. For example, in trade or commerce, the Competition and Consumer Act by Section 52 says one can't make misleading or deceptive comments, engage in misleading or deceptive conduct in trade or commerce.
But specifically here, just so we don't confuse matters too much, we're specifically here talking about the Racial Discrimination Act.
That's right. But the reason I gave that example is there are certain areas of policy where there are good reasons why the utterance of falsehood should be against the law.
But not, for instance, Holocaust denial.
Such as where people transact business in trade or commerce. But here, in the Bolt case, what we're talking about is the making of a comment or the utterance of a view about a political question. Now, just think what the implications of that are, Emma. If you can be prohibited from expressing your political opinion about something merely because you make an error in your argument, what a gross invasion of the capacity of everyday Australians to express their opinions that would be if you could be taken to court merely for saying something that was factually wrong.
Well, let me just quote something from Justice Bromberg's judgment, because in the specific case of Wayne and Graham Atkinson, two of the co-complainants here, Mr Bolt said that they were Aboriginal because their Indian great-grandfather married a part Aboriginal woman. This was to justify his argument. The facts given by Mr Bolt and the comment made upon them, the judge said, were grossly incorrect. Not just a little bit incorrect, but grossly incorrect. The Atkinsons' parents were both Aboriginal, as were all four of their grandparents and all of their great-grandparents, other than the one who was of the Indian great-grandfather that Mr Bolt referred to. Now, when someone is of the position of Mr Bolt, that is, with great influence and given the many numbers of readers who read his columns, isn't there an expectation that he at least get his facts straight?
Well, whether there is or not, there is a broader principle at issue here, and that's why I'm a bit reluctant. You're treating this as if it's all about Andrew Bolt and a particular case.
Well, with respect, you did raise Mr Bolt's case on a number of occasions today.
I did, and that's because that case, more than any other event, showed the unacceptable breadth of the existing Section 18C. But it's not just about Mr Bolt or the Bolt case. What this is it's about the assertion of a very important principle, and that is government shouldn't, through its agencies, whether human rights commissions or courts, be able to prohibit political discussion just because somebody makes a mistake in their argument, whether it be Mr Bolt or whether it be any citizen in the land. That is not an appropriate extension, in the government's view, of the power of the state.
Senator, in your press conference today, you said that the words offend, insult and humiliate would be removed from the Act because they stifled robust public discussion. By way of example, you referred to the Parliament as a place where you all offend and insult each other every day. Can you give me a recent example of a racial insult in the Parliament?
I've heard racial insults in the Parliament. I can't give you immediately an example, but I have definitely heard racial insults uttered in the Parliament. And might I make the broader point that I think that it is an impertinence for legislators to impose upon the citizens a prohibition which they themselves do not observe in parliamentary debate.
Although standing orders do prohibit certain offensive language in the Parliament.
But look, I'm sure, Emma, you and all of the viewers of Late Line are sufficiently familiar with watching Parliament, or at least watching Question Time, to know that there are often offensive and insulting words exchanged. And the answer to your earlier question, yes, I have on several occasions in the years I've been in Parliament heard racial slurs. I don't condone them. They are wrong. Racism is always wrong. That's why we've toughened the Racial Discrimination Act by putting at its heart vilification, which wasn't there before. But the way to deal with racism is not to censor public debate. It is to identify the invidious conduct that is the essence of racism, that is the incitement of racial hatred, and attack that.
You say you've toughened the Act with your measures today, and so I want to talk about the exemptions you've outlined. You say your amendments don't apply to people expressing opinions in private, and nor does it apply to, and I'm quoting your Section 4, words, sounds, images or writing spoken, broadcast, published or otherwise communicated in the course of participating in public discussion of any political, social, cultural, religious, artistic, academic or scientific matter. So with all those exemptions, who are you expecting the law to apply to?
Well, 2 points. First of all, you said that our changes don't mean that the Act doesn't apply to conduct engaged in private. That's true, but they're not the product of our changes. That was a provision in the pre-existing Act, so there's no change there. Let me give you an example of conduct that would constitute racial vilification and wouldn't be caught by that exemption, and that's the utterance of abuse, the utterance of racially motivated abuse. That's not participation in public discussion. It doesn't go to any of the topics that we have adumbrated in the proposed subsection 4. If a person yells racial abuse at someone in the course of a sporting game, for example, then that is something that would be caught, which wouldn't necessarily, by the way, have been caught by the previous Act.
OK, let's go to the other news of the day. Why is Australia, a proud and independent country, reintroducing British titles?
Well, they're not British.
Dames and knights.
No, they're not British titles. These are orders within the Order of Australia that have been in abeyance now for quite a number of years, but there was always the order of AK Knight and AD Dame at the highest rank of the Order of Australia. So these are actually this is a domestic Australian honour. And the reason is because the Prime Minister was of the view that there are certain Australians who have given such exceptional service to the nation, like the retiring Governor-General, who will now be Dame Quentin Bryce, that they should be given a remarkable honour beyond the existing post-nominals.
What will it mean for those 4 people awarded the honours each year? And indeed, what will it mean for the person in the street?
Well, I think that it's a seemly recognition of the greatest Australians. I don't think it means any more than that. But Emma, Australians should celebrate our greatest citizens, and we do. This is just another way of acknowledging them, respecting them and celebrating them.
Doesn't the government of the day run the risk of people refusing to be inducted into this honour system?
Oh, well, that's the case with any honour. Under the Order of Australia at the moment, and years ago when it was more common for knighthoods to be awarded, these honorifics are always voluntary.
Senator Brandis, we'll have to leave it there. Thank you so much for your time.
Thank you, Emma.